net because I've been on net for a long time today. We'll start giving problems. Somebody is going to rejoin. Soumya. Maybe she thought there was a network issue while I wasn't speaking. Tell me, any leftover questions from past classes? Or any thoughts which have occurred to you since then? Are we ready to discuss today domestic violence? Hello?
Yes, ma'am, you're audible.
मैंने तो पूछा ही नहीं audible, मैंने तो जवाब. What do you think is domestic violence?
Any kind of violence which happens between the private bounds of private spaces, homes, etc.
Okay. So who are the perpetrators of domestic violence and who are the victims of perpetrated violence, generally speaking?
Its perpetrators are usually men, and victims are usually women and children.
But we have all heard about the mother-in-law, daughter-in-law issues. Whether this legislation, the legislation which finally came in 2005, does it address the question of daughter-in-law or the mother-in-law harassing the other? Or is it men versus women? Maybe before going to the legislation, today we are not actually going to talk about the legislation, the act we're not talking today. Want to understand, so we do know, we have been, I think this is acknowledged by all of us, that the family sphere is a very hierarchical and patriarchal structure in which the status, power, control is a lot more with the men. So when somebody has got power and the law said private sphere, we will not enter. The law will not enter the private sphere. And remember the statement which says allowing law to enter the family sphere will be like allowing a bull in a china shop. So what does that tell us? What is the understanding of the judge who wrote the sentence about what is the nature of law? Whether the construction of law as a bull is in consonance with our understanding of what is the role and function of law. What is the purpose law serves in the public sphere?
In the public sphere, it regulates behavior between a public in the general, as in between two individuals, and also it regulates our relationship with the state.
So does it regulate or does it oppress one party against the other? It gives power in the hands of one party to the disadvantage of the other party.
If we see law only as a penalizing provision, then necessarily when it penalizes someone for the acts that he or she might have done, then it puts that person in a lesser position, in a powerless position, and the person who got the relief in a much more powerful position.
Would you say that the people who are accused of offenses and are prosecuted and tried and then convicted, they do not get a fair trial? Are there no checks and balances on the exercise of that power?
Mostly, the it has been seen that mostly the accused persons in all of the offenses, mostly there are the less privileged. They belong from the less privileged classes, whether they are poor or Dalits or women.
So no, so that's true. But does that indicate that the function of law is to oppress, or it functions in a manner that it oppresses?
The latter would be true, I think.
So then, therefore, we are not saying in the public sphere it will destroy anything. We say it will equalize, it will promote justice, it will maintain law and order. So all the positive functions are attributed to law when it operates in the public sphere. So why is it that it was believed and it still is believed there's resistance to allow law which will ensure equality, justice, and peace in the private sphere? What are the possible justifications for that? And especially knowing that private sphere is not a sphere of equality. If it is a sphere of equality, do we need the law? If there is a couple, there is a family which is looking after each other's needs, there's a lot of love and affection. Do you need the law? Well, we say families are places where people have natural bonds of love and affection. So that is what how we construe the family. That's a place where people are dependent on each other, they take care of each other, they're bonded with love and affection. And this is natural because you're born to those people, you grow up with other siblings, and therefore these are natural bonds of love and affection. It doesn't exist in the in the public sphere. Public sphere, you go to an office, you do not know those people. So these are you're dealing with strangers in the public sphere, while in the family, you're dealing with the people you have grown up with, who have given birth to you, who with whom you have a sacred relationship. Because if you look at nature of marriages, even though we say Muslim marriage is a contract, but it still is a religious union. So it is binding two people in a spiritual union. It's a sacrament. So if that is all there, which does not exist in the public sphere, so therefore there's no need to have the law. That's how the logic works. Logic of the person who says, no, we do not need the law in the private sphere because naturally people will be taking care of each other. As long as people do take care of each other, you don't need the law. The same is true for but the understanding in the public sphere, the possibility of conflict is a lot more because there is no love and affection, there is no bonding, there is no growing up together, there is no historical relationship between the parties. In the private sphere, it's completely a different sphere. So one, when it's a love and affection, these are very delicate matters. Little bit of law, and law is impartial. Law does not look at who is who. Law applies equally to everyone. But in the family setup, you do a lot of compromises, you do a lot of encouragement. You will the principles of equality, freedom, liberty do not apply, should not apply in the same manner because you don't need them. The father is supposed to look after the children, provide the the economic needs, whatever the children and the family, the wife and parents and the family member they need. The men will provide for that. What the women will do, they will provide love and affection and care. It's a very clearly demarcated sphere of operation where people take care of each other They are connected with each other, therefore you don't need the law, which is an alien to that whole scenario. And like in a China shop, everything is very fragile. It can break. The relationships can break if you now bring law. And that has been the argument also that we have now brought in the Domestic Violence Act, we brought in 498, and now see how things are going bad. People are now using the law, women are using the law to destroy the families. So therefore, the argument initially, which was the statement, we said that no, allowing law to enter the family sphere is like allowing law to bull in a China shop. People say this is what's actually happening. Do you agree with that statement?
Definitely not.
Why not? You've not heard about abuse of
Uh,
498A?
Ma'am, can you repeat that? My internet was being weird.
I'm saying that have you not heard about 498A being abused, destroying everything in the families? Women are now misusing the law to harass their family members.
I think that's really rare. And if anyone would like to contradict, then definitely. But I think the abuse itself is too prevalent than the abuse of that particular law.
Mm-hmm.
I think one
So
of
do we
the
remember the data? Do we remember the data of domestic violence? What is the extent? And when we say domestic violence, are we talking about domestic violence only against the married women? Or we are talking about domestic violence of any member in the household? Or are we talking about domestic violence against women? They may be sisters, daughters, wives, mothers. What are we talking about?
according to the act, is an aggrieved person can only be a woman who has been in a domestic
No, no,
relationship.
no, no, no. The point I was making was that is it married women or women that we are talking about who are subjected to domestic violence? Not that no man is ever subjected to domestic violence, but what are the facts which are alarming, because of which we got all these laws, special laws to deal with the issue of domestic violence.
It says any woman, and in the recent years, live-in relationships have also been recognized as a space where domestic violence can happen by the courts.
Mm-hmm. Do you think domestic violence is of a recent origin? It's now that women have started making the hue and cry, and it wasn't there in our olden days, good olden days.
Definitely not.
Do you have cases of domestic violence?
I mean, the case material, there's one Hiral or something.
तो आपका है ना, किसी और केस में किसी और कोर्स में domestic violence के cases पड़े हैं criminal law में, which is not on the current legislation, but there are recognition that there is domestic violence.
There are no cases based on this legislation, but there are references, as in the cases of Dirajia and Garsibai. The judge
Yeah,
refers very casually that the husband used to beat up the wife.
very categorically, a century ago, the recognition was that this is normal. So not only that existed, but it was normalized. So there was nothing wrong about husband, and this is as the wont of the husbands are. They were, he was beating the wife. The wife was scared to death. So that was presented as a non-problematic scenario. Problem was that she jumped into the well. The problem was not that she jumped into the well because there was a husband following and she was scared to death of that husband. So that was not an issue, because this is how men are supposed to be behaving. So there was no problematization. The problem existed, but this was not seen as a problem. The situation existed the same. So a century later, things haven't changed. So we say women progress, women empowerment, all that. But if in the 21st century we still have the data which says 1 in 3 married women are subject to domestic violence, what has changed? Not only that, we are saying the next generation of women is not permitted to be born. Even the existing women, they're tolerated, but subject to beating by the husbands. So if the husband is beating and the everybody thinks, the neighbor thinks it's normal. Have you seen that film, Each Other Malici? Kind of film, but it's based from a story. So there's a scene there which kind of has been etched in my mind. Hema Malini is the woman who is being beaten by the husband. So our neighbor intervenes. That how can you beat her so badly? And it was a case of where the uh, no, her husband had died, and there was a tradition that the devar would put a chadar on her, and then he has to act as the husband of this woman. So the devar was in love with somebody else, he didn't want it, but he was forced to do that. So he was very abusive to the hubby and now the wife. So the neighbor intervened. She said, "What is your business? My husband, he is beating me. None of your concerns. If he beats me, he also gives me gifts." So it was seen as a very private affair, husband wife beating, etc. It was again seen as an affection and as a sign of that no पड़ोसी की औरत को थोड़ी पीटेगा because he has got rights over me because that belong to him, therefore he can beat me. So this was the manner in which women were brought up to accept violence as part of their married life. And the studies on domestic violence tell us that there is a cycle of abuse in domestic violence because we know that women remain in domestic violence violent households for long years, 10 years. We know Kiranjit Ahluwalia. After 10 years of long-term domestic violence, she then retaliated and we said slow burn syndrome and all that. But she was educated, she was working. Why was she staying in that household for 10 years with so much of abuse? So one has been this whole understanding of how the women construct this world. And I think we've done that before, that women construct this world as being connected to the other. So they feel connected even to the abusive men. They keep on feeling, waiting for that period when he will, but they don't have a problem with the man, they only have problem with the conduct of this man. So the man is fine. He is, after all, a human being, and we are connected. All human beings are connected. So her construction of the world is caring for the other. So she keeps on waiting, and this abusive husband, all abusive husbands, have a very common tactics. You look at cases across yourself, and you will find that every woman you know, in your family, in your neighbor, anyone you have heard of, they will be subjected to a same techniques by each one of those abusive husbands. One will be isolate the woman. She will not be allowed to invite friends, invite family, go and meet them. So first technique of all abusive husbands is isolation. As it is, the girl has left her family behind. Now she is alone in that new household. So this household will not encourage her to retain those relationships. In fact, make the other people so uncomfortable that they will stop coming. And if they come, they will be wanting to leave very early. So that's the first technique. The second technique is to destroy the confidence of the woman. Find so many faults in her behavior, in her conduct, in whatever she does, that she start doubting that I must be doing something wrong for him to lose his temper. She doesn't see this as a problem. So there's a self-blaming and the loss of confidence happen. The third thing which this man does is to there's a cycle of violence, which means that there will be a period of romance, then there will be building up of tensions, and then there will be an explosion. And there is no rationale as to when this explosion will happen. So she cannot predict that if I do this, he's going to blow up, or if I don't do this, he will blow up. She has lost one, her ability to share it with anybody else because now nobody is there for with whom she can share. She and also we've been we bring up our daughters also say that घर की बात घर में रखो. So she doesn't want to share, and then she is not enabled by the oppressive and confinement to share. And then because there is a cycle, she feels कि ठीक है हो गया, he'll be fine tomorrow. आज उसने शराब पी ली थी, आज वो बहुत टेंस आया था हस्बैंड वहां से. She finds excuses as to why he blew up. So she just accepts it, and she keeps in this hope. One is that relatedness with the abusive man. The second one is the hope that he will take care, and also reinforced by this romance period after every violence. So it is not, it is every day kind of a thing. Then there are these other factors, which is the economic dependence, the social ostracism. These are all additional factors. These are not only integral to the woman's upbringing. These are the other factors which does not empower the woman to leave that household. So she sometimes does leave that household, goes to the peer. Previously, we knew the law did not allow her to have a right of residence after her marriage. So not only that she did not have inheritance rights, the law did not give her even the right of residence. So if she leaves this household of the husband, matrimonial home, where does she go? Then we have constructed woman as the carer of the children. So if she has got children in the household, it's even more difficult for her to leave. Because even if she's alone, she may still think कि मैं घर के कोने में पड़ी रहूंगी, मैं उनका काम कर दूंगी, कम से कम मुझे वायलेंस तो नहीं, what I have to do here also, मैं अपने भाई भाभी की स्लेव बन के रह लूंगी, वो मुझे मारेंगे तो नहीं. But you got children, then expenses involved. So she is completely caught up in all these bringing up values of her own with the economic dependence she has on somebody. Somebody has to look after. And there are very few people who are ready to. Now you will have all the Raksha Bandhan and Bhaiya Dooj. But when it comes to bringing your um, sister who is being subjected to domestic violence to your home, it's not something which very many brothers do. The girl can still come if the parents are still there. They certainly, comparatively, it's just a question of who is capable of doing whatever. So if the law says, now of course we have abolished that section, and now we have also granted for passing all kinds of economic rights there. But earlier she had nothing. So even if she has all these issues of domestic violence, there was nothing in the law which supported her decision to separate or go away from that violent place. Socially speaking, single women are not seen as good women. The blame is on her. Something must be wrong because of this. The husband has chhod diya usko. So then she becomes the subject matter of lust of all the neighbors, the neighboring men. It's a very difficult time. And also, many a times, if this woman happens to have any male friends visiting her, living alone, it's very easy to put the tag of the stigma of being a prostitute. She's doing sex work. So she's got all these issues to deal with if she decides to go away. So where are the choices for her? In terms of physical strength, she cannot beat up this man who is taller, older, more educated, more finances, everything. He's in his own family. You have come from somewhere else. So the patrilocal, patrilineal, and also hypergamous marriages makes it impossible for her to do anything on her own. Even if she finds that strength, goes to the police station. Now, who are at the police stations? Even if they're women, what is their value pattern? The same. अरे घर में झगड़ा हो जाता है, दो बर्तन है तो खटकें गई. This is how the whole attitude of the world has been. And therefore, for her to even file a complaint is a very difficult thing. अरे थोड़ा सब्र रखो, ठीक हो जाएगा, हो गया, आ गया होगा गुस्सा. So nobody is there, neither the legal system, neither nor the legal norms, nor her own family are supporting her. Friends have been alienated, and friends also cannot support her in the manner she would require support if she leaves that husband's house. And then we say, oh, why did she go and commit suicide? Why did she kill herself? Ranjit Ahluwalia was a case where she did not kill herself, or she killed the husband. 2 days back, there was a news where a woman had killed her husband. Did you see that? Recently, a married woman She killed her husband, then she walked 20 kilometers and surrendered herself in the police station. And that I was just sick of the violence. Therefore, that's the end of it. And I was just reminding all our stories of battered women who kill. So we found this one case very recently. If you do the search, I'm quite sure you'll find it on the net also. So here is another instance, because somewhere, so this has been the whole idea that either they kill themselves because they have reached their patience level. Either they kill themselves by that time. Kiranjit, Rajia, Gyarsibai are the examples of that. And Kiranjit Ahluwalia, where they attack the other, the abuser. And the law does not take cognizance of that condition. So those reactions are not seen as correct one. So now what did the law do? So okay, if you were to look at IPC, are there any provisions in the IPC before 1983 which deal with the issue of domestic violence? So if the husband breaks her arm, grievous hurt. So she files grievous hurt complaint and assume that grievous hurt complaint has been registered, which is a miracle. But suppose it has been registered. What will happen next? Grievous hurt cognizable offense? What will the police do?
Suggest a settlement.
Hmm? What did you say?
Suggest a settlement, I would say. Suggest a settlement. They just suggest कि आप अपना आपस का मामला
नहीं,
सुलझा
FIR
लीजिए.
FIR हो गई अब तो. FIR होने के बाद में क्या होगा? अरेस्ट होगा. कॉग्निजेबल ऑफेंस है
Yes,
ना.
ma'am.
तो अरेस्ट होगा तो ये औरत कहाँ जाएगी? कहाँ से खाएगी? So even if the police did react, she doesn't get to live anymore. No, she doesn't have any subsistence anymore. उसका husband arrest हो गया तो शायद नौकरी भी छूट जाएगी. अगर नौकरी करता था या अगर बिजनेस करता तो बिजनेस ठप हो जाएगा. Do you think she will be allowed to live in that household? रिजल्ट वही का वही आ गया. और मेंबर्स भी तो है ना. Everybody is now suffering because this woman filed a complaint. Is it easy to live with that blame on her? So nobody is saying कि उसने उसका हाथ तोड़ दिया, इतना मारा उसको, नीला कर दिया. That's not the issue. Issue is now we are all starving because this woman made a complaint. Are you aware of what were the initial laws, which what are the various practices, socially sanctified practices, which cause violence against women? Socially accepted practices. And when was it that the law started taking cognizance of those practices?
The Sati's dowry.
Sati dowry. So do you know when was the Sati law first Sati law made?
I think the first half of the 20th century. First half of the 20th century, I think.
Let me see if I have the
Under one of the figures of the freedom movement, I think. Jyotiba Phule.
1829. This is how many centuries ago? 1829. 200 years ago. Practice of sati, or of burning or burying alive the widows of Hindus, is revolting to the feelings of human nature, is nowhere enjoined by the religions of the Hindus, as an imperative duty. The contrary, a life of purity and retirement on the part of widow is more especially and preferably inculcated. And by a vast majority of that people throughout India, the practice is not kept up nor observed. In some extensive districts, it does not exist. In those in which it has been most frequent, it is notorious that in many instances, acts of atrocity have been perpetrated which have been shocking to the Hindus themselves and in their eyes unlawful and wicked. The practice of sati or of burning or burying alive the widows of Hindu is hereby declared illegal and punishable by the criminal courts. It's not that something, this is kind of as old as 200 years ago. It's not 20th century. It's early 19th century. We're in the 21st century now, 2021. So just 9 years less than 200 years since we started talking about it. Do you know what are the areas in the country where sati was more prevalent?
In
What is
the
the birth?
in the
This
Hindi
one says, hmm?
Hindi region, in the Hindi
in,
belt, I think.
in the
Hindi belt, Hindi region, Rajasthan and Uttar Pradesh and Bihar.
lot more in Rajasthan, which was lot more actually Johar, and then Sati. The other one, which was really notorious, was West Bengal. Bengal, not West Bengal at that time, it was Bengal. Raja Ram Mohan Roy comes from there, and he saw his bhabhi being pushed, and that is where he became aware of the torture which was being subjected to. And West Bengal is an area where the Abhag system was prevalent. And the rest of the country we have Mitakshara. So Mitakshara women had no right to property inheritance. In Dayabhaga, widows had a right of inheritance. And to prevent the property going to the widow, and then she might remarry somebody else, don't kill her. Neither na widow rahegi na property jayegi. So in the name of religion, just seeing that no, this is your duty. Pati Parmeshwar has gone to you, also go with the Parmeshwar. So when you create this whole status of the husband and the widow as the one who doesn't have a right to live anymore, but what you are doing ultimately is saving your property. In case of Rajasthan and in the northern belt, it's not more started from Rajasthan. And even now, it's Sati Mandir, etc., a lot more prevalent in Rajasthan than I think in MP or UP. So Rajasthan was an area where a lot of aggression was happening. So in order to then save the honor of the family, the whole Johar thing started from that idea that they meant that the enemy must not be permitted to defile the woman, defile the race. So it was a lot more to again the symbolic, the women life was not more important than their honor. And that you get, that those values are still prevalent. Those values haven't changed. So she can die fighting the rapist, but if she acquiesces, then she's a woman of loose moral character, not to be believed. Parting money under fear of death is okay, but parting with your chastity or your virginity under fear of death is not acceptable. You should fight to death in order to save your honor. So you should die if your husband has died, because other people might defile you. So certainly, when you look at the locale of these two practice of the practice of sati, it was not across India that it was there. This was very much guided by factors other than the woman's own wish. She never existed. These were values other than aspects other than her own self that was responsible for the practices to flourish. So going further, we have got now the 1987 legislation. So from 1829 to 1987, again 100 years or more than 100 years, 1.5. 150 years, close to that. So we are still dealing with that. We were still dealing with 1987. We again had the issue of sati still raising its hand because the practice did not stop. You declared it illegal in 1829. Practice continued. So we had rope cover. That was the incident which led to this whole thing. So rope cover, and when you look at that whole family status, when you look at the politics of sati now, the woman who commits sati, when she becomes a devi, you establish a temple, and the money which is offered through such temples for 7 generations, men in those houses, the members of those families, need not do anything. From the offerings to the Sati Mata, they can live happily. So again, there's a lot of economics involved there as to you force one woman. So it's not a question of a woman voluntarily wanting to do it. Rupkawar was being pushed to kill, pushed to die on the, and no, first the women are drugged and then they are put on the pyre. So it is not that it is her wish that no, she's so now hopeless of the whole world that she wants to kill herself. It were other people who were pushing that, and then it became a business, a good business mechanism that you push her, she becomes a Sati Mata ki jai, and then you got a mandir. There's a whole of lot of economics flowing from there. 7 generations. So then we, 1987, we got this new legislation, which was focused not on the practice of sati, but on glorification of sati. So attempt to commit sati, abetment to commit sati, if committed, all this abetment to commit if attempted. Glorification of sati became the key point there. And the case we have, the punishment for this was imprisonment and fine, mandatory minimum imprisonment and fine. Disqualification from election is the range of punishment which have been provided for this law. So when you look at this one, attempt to commit all this. So glorification is nowhere that this is where we have this case which we will read after tomorrow as to what constitutes then the whole issue of interpretation. You make a law and then you have to say what practice will amount to glorification of sati and which will not. But anyway, so that's one story beginning from 1829, recognizing that we have a problem of violence against women and a very serious one at that. Take the law, nothing happens. Nothing happens in the sense of the practice does not stop. And all these practices of violence against women are socially accepted, presented as religiously desired. So there will be some justification, there will be some link. So remember when we're talking about patriarchy, we also, Kamala Bhasin does talk about that religion and other structures and institutions are reinforcing the same control control is justified in the men. So this is the social structure supported by the religious, in the name of religion, harassment, violence, killing of women is seen as not a problem, not justified, but not a problem as either. So then the other one is the dowry issue. When you look at dowry, we've been having changes in the law. So we got Dowry Prohibition Act in 1961. So 1961, we said giving, taking, demanding dowry is an offense. 1961 to 2021, how many of you would want to have dowry? And I'm talking women. At the time of your wedding, you would want to have dowry. And make a distinction. Dowry is the gifts, money, etc. given to the groom and his family. Sridhan is the property, jewelry, clothes, things given for your personal use. So I'm not asking you whether you would want to have Sridhan at your wedding. I'm asking you whether you would like to have dowry. at the time of your wedding.
And there's a like a as a custom reasonable exchange of gifts on both ends, but it has to be like on an equal footing where there's an actual exchange and also proportionate in the value. But if it's something like if it runs into lakhs and crores, then it becomes more than just a custom and more than just a
Suppose
gift.
your no no. Suppose your father does have that lakhs and crores. Is capable of giving it to you. And the other side is saying, okay, you have crores, you are Ambani's daughter. So give me an aeroplane, give me a charter plane, give me, 5 different jets, give me 5 villas, buy me an island. And your father can give it to you. It's not that he can't give it to you. So should he be giving it to the groom who's asking for all these gifts?
Because a marriage is for the people, for the couple, not because of all these perks. Then it becomes, then it just becomes a sale more than a marriage.
No, no, because the whole question, because when you were saying that it should not be crores and lakhs, and it should not be beyond the means. So whether that is our criteria to determine that how much money should take place, should exchange, whether that is that has got any problematic aspect about it.
No, like, if there's an exchange of gifts, then
Yeah.
it's fine. Yeah. But not like a show buddy.
No, exchange of gifts में आपकी मदर ने आपको एक वेरी ब्यूटीफुल गोल्ड नेकलेस दिया, आपके सासू ने भी आपको एक हीरे का हार दिया, and then your family gave to the groom the best clothing and also a सोने की chain, and your mother-in-law gave you a very beautiful, very expensive lehenga. So there all this exchange of gifts are happening. Your mother is giving things to him, and your mother is giving things to you at the time of the wedding. It is all displayed. हमने क्या दिया, उन्होंने क्या दिया. What is the message we are giving to people?
And personally,
When your maid's daughter gets married, and they have seen all what has happened here. And it's not only your maid, there will be a lot of other people have seen it. So whether we are promoting a practice of saying gifts exchange is essential part of weddings cannot take place, and then it will vary. So whether you thought that no, because your parents are capable of, so you had a plush wedding. Now the maid's daughter is to get married, and their groom also says, "अरे आप इतने अच्छे घर में काम करती हो, आप भी अच्छे से शादी कराओ." Your father is not going to give money to her, but we have now created an atmosphere. This is rather I'm just talking about that high class by their expensive weddings, etc. That was the whole logic of saying nobody will have this show of business, big marriages. You will not have more than these many guests. Not only COVID, before COVID, they put lots of time limitation on the number of people you can invite, and that had nothing to do with how much you can afford. Maximum you can have 100 people in a wedding. If you're having that, that was illegal. Because when the moment you say, I can afford 1,000 people ka shadi and I will give them good food, I'll have 40 stalls or 50, 500 stalls for them. So because I can afford it, that was seen to be creating a norm which is not met by people who cannot afford it. So it was not only a personal affair, because marriage is not a personal affair कि दो लोगों के घर में कोई जना तो आया नहीं, आपने जितना यहाँ दिया, it's between private affair. Marriage is a public affair. And in the public affair, now you are creating expectations from other people who are completely unconnected with your wedding. But you call all them, you called all of them. So now the girls are deciding कि अरे मेरी शादी में भी ऐसे ही 40 stalls लगे, मुझे भी इतना बढ़िया लहंगा खरीदना है. So you are now creating an expectations in the girls, you are creating an expectation from the boys, and then in this setup where we think the boys are more educated, not think, when we look for the boy, we're looking for the better educated, better house, everything better, So in the hypergamous marriage itself, we have created an inferiority of relationship. And then the girl side tried to bridge that gap by offering gifts and things, etc. Not only to their daughter, because to their daughter, what the gift she can keep as for her happiness, but she also thinking, the girl's logic has been of asking for dowry in their weddings is that we are not going to take a share in a property. We're going to give that up. इसलिए हमें अपना थोड़ा हिस्सा तो शादी में दे दो, but brothers will get everything later on, and we do not want to lose our brother's love and affection. Therefore, it is my legitimate right to ask for a share in the name of, in the form of dowry. So this is how the girls logic also, one is the dream, where a dream है मेरी बड़ी सी शादी हो, लड़का वो सफेद घोड़े में आए, so all these dreams created in the girls' minds, and then coupled with this whole system of the woman will go and nobody expects her to claim her share. Even though now today law says she has a fair, she's a co-pastor, everything, but she's not living here. What will she do in this house? She will only destroy. These two brothers are living here happily. They have divided first floor to one brother, the ground floor to the other brother. The third floor is on rent, and they are kind of getting the rent out of it. What will she do? She's not going to come and live here. She has a husband who has got a lot of money. Why does she need this house? तो शीज़ा यार यार मैं भी नहीं लूंगी, मेरे तो दोनों भाई हैं, उनका एक बार अच्छा खर्च चल रहा है तो अच्छी बात है, आई डोंट नीड इट, आई वोंट गिव इट, बट देन एटलीस्ट मुझे भी तो कुछ दे दो, पेरेंट्स तो मेरे भी थे. So this whole logic works. The boys think it is perfectly fine. And do you think it's a fair bargain that because they will leave, they will not be taking the landed property from their fathers, they will be giving it up later on when the property will be available uh, dissolving, for what is it, that devolving. So is it a fair deal that they say, okay, give me money at the time of marriage?
And the conditions itself aren't really fair. But
Like what?
if given the structures that exist, if you admit that patriarchy exists and this is how it is and you've kind of given up, it's not fair. But if she can accrue any sort of benefit, then I understand the motivation, but then I'm against the system. I won't vilify the woman, but I would vilify the system, which um, makes this her last resort to have any kind of economic autonomy.
No, have you ever asked, ever you heard a man saying, give me money at the time of marriage? Because after marriage, I'm going to move to England. I'm not going to live here. Therefore, give me my share. I will not claim share in the property on my father's death. मेरे शादी में मुझे पैसे दे दो. I do not want to lose the love of my brother, and I will not ask for that share. At the time of my marriage, please give me that money.
I'm definitely a patriarchal enablement of her demand. Definitely.
So when the brother was gone and married and is now living in England, and he asked for a partition of the property, that's not an issue, no? He's also not living here, but we make it an issue, and there is no loss of brotherhood. But like, unless the brothers don't, they become greedy or something, it is more accepted among the brothers कि भाई का तो हिस्सा होएगा ही. But when it comes to the sister, because she never had a share, now the law says a share, then the choice is love and affection or property. And they are emotionally blackmailed to choose love and affection over property. The sisters are not told that brothers can choose also love and affection or property. So if the brother chooses property over love and affection, that's okay for him. If the chooses why should that be a choice between love and affection or property? It's a legal right, she should get it, but the manner in which we have created all these norms. Do you know what is the source or what is the religious basis because of which um, dowry started? Where are the roots? You know what are the ceremonies at the time of wedding, Hindu wedding?
I'm like, sure, wouldn't
Kanyadan.
What do you say, Ria?
Kanyadan.
Kanyadan. So Kanya becomes the property first of all. And then we have a tradition that if you give dan, you have to give dakshina, varadakshina. So the whole dowry thing started with the varadakshina. Remember the story of Raja Harishchandra? वो आया ब्राह्मण दान मांग गया तो उसने बोला मुझे सारा अपना राजपाट दे दो दान में तो दे दिया बोला कि नहीं तो दक्षिणा भी तो देनी है ऊपर से तो दक्षिणा तो अब उसके पास था नहीं तो देन ही टू सेल हिज वाइफ एंड सेल हिज सन तो राजपाट तो सब पैसा तो सब उन्होंने ले लिया सो दक्षिणा इज एसेंशियल after give a dan. So first you objectify the woman. Then you say, and also Kanya Dan is the biggest dan you can give in your life, and everybody has to give a Kanya Dan. To give dan, you have to give Vardakshina. So that Vardakshina, which was supposed to be voluntary offer of something more than the Kanya, became the source of dowry. And initially it was just all voluntary, but then it came to be seen as a right of the Var to ask for their dakshina. Like the Pandit had asked, this is my right to ask for dakshina if I've taken a dan. So the whole practice in which we perform the Hindu wedding is very categorically creating property rights of the recognizing the property rights of the parents over the daughter and giving it on those property rights to the husband. So no wonder we say there is no marital rape, there is no right of the name because she didn't have a name in the first place. Only sons have the names. So she can be given not only the surname changes, many families the tradition that her maiden name, the first name also changes. This is all seen as giving a new identity, which means completely taking away her past from herself, from her. For days she doesn't even respond to the new name because this is not what she's used to. So completely alienate her in this whole ceremony. And so the sources are seen, and today it is not limited only to Hindus, the issue of dowry. And a lot of us believe that no, it doesn't happen in our family. And especially the community, Banya community is asserts is a lot more that because it's all open, it's out in the open that there is a bargain, there's a proper conversation, there's an agreement. So if what the groom side is asking is not acceptable to them, they can always refuse. So the harassment doesn't happen because it is only after agreement of the two parties that the marriage takes place. So whatever has been desired by them, the parties agree, their marriage takes place. They don't agree, the marriage doesn't take place. So is that okay? What is wrong in this practice? Anything wrong? Not from. आपकी बिसात नहीं है तो मत करो लड़की की शादी
Ma'am,
अरे घर में दूसरा घर ढूंढ लो
everything is wrong in this practice because we are not contracting. We are not entering a sale of contract for a commodity that we can negotiate the the weight, the height, and the price at which to sell that commodity. And if you accept it, then buy it. If you don't accept it, then move to the other shop. So it doesn't happen that way. We are dealing with human beings and human emotions.
whole
So
bargain thing actually puts price on both the sides. मेरा लड़का IAS है इसका 1 करोड़ लगता है वो क्या सेल हो रहा है उसकी ये पार्टी नहीं लेता दूसरी पार्टी ले लेगी उसको 1 करोड़ में. So there was a time when all these things came up that how much was the doctor costing, how much was the IS officer costing, how much was the other different graduate costing. So there were all this costing done for the grooms as well. That this is the cost. If you can afford it, you can take him. But of course, that does not mean that. This is kind of little strange that when you're purchasing this groom in that bargain, but still you do not have any rights over that groom. He still has to be continuously kept being given more and more, not only at the time of wedding. अब उसका birthday आ गया, अब दिवाली आ गई, अब दशहरा आ गया. So throughout your life, will keep giving to that man whom you have secured as your daughter's life partner by paying lot of money. The issue with all this scenario had been that even though the moment it comes to somebody asking and specifying that this is what we need at the time of wedding, the expectations do not stop and the demands do not stop only at the wedding. Then there are demands. Now, son has been born. Now the daughter is getting married. Our daughter is getting married. So you must also bring even for that wedding. So for every single thing, continuous demands. The moment a family demands once, they do not stop at once. And there are expectations for all the things. And even when there is an agreement, अच्छा हमें कार दे दिया कार, जैसे भी, and most of the time the bride's family are borrowing money to give that car. अरे ये तो इन्होंने तो वो दे दिया, कौन सी कार, छोटी मोटी कार दे दी, बड़ी वाली नहीं दी, बड़ी वाली दे दी तो नहीं नहीं इससे भी जो बड़ी SUV है ना वो नहीं दी. So the identification of कि what was expected, क्या अगलियों के साड़ियां क्या दी हैं, 100 रुपए की साड़ियां दे दी. So there is this quality check also. The thousand things which keep on happening. हाँ एक दे दिया, दो तोले का हार. अरे कम से कम एक डायमंड तो होना चाहिए था. लड़के की रिंग देखो कितनी छोटी सी है, इसमें इतना जरा सा डायमंड लगा. So the criticism never stops. The evaluation of the substandard quality of the girls' gifts are never stops, and it multiplies. And it becomes certainly very hard for the girl who has come from a completely, has been transplanted, doesn't have the soil where she can flourish. So then, in addition to all that, so dowry has become a very, very um, uh, troublesome and we a practice. And 1983 was the time when, so 1961 when we got this law, nothing actually happened. This was brought as a symbolic legislation. That there was no mechanism provided for implementation of that law. So 1961, when we brought this law, there was not a desire for implementing this legislation. It was just a symbolic, okay, we recognize there's a problem and we need to do something. So we brought a law. In 1980s, lots of brides were dying of burning, and they were all being referred to as accidental deaths. And it was very strange that all of them were dying because the stove in the kitchen burst. There were these kerosene stoves, and you had to pump air into them. And then it used to be, so you will put kerosene at the bottom, and then you have to put pump, and then you have to. So sometimes they did explode. But then there was an explosion of the exploding of this cooking stoves. And very strangely, it was always the brides who were dying in those burnings, in those stove. So the very strange that it is only the woman who, there's only the new bride who is working with the stove and she dies of the burning. Never a mother-in-law got injured, never a sister-in-law got injured. So then it was a recognition that it is actually bride burning. They were burning the bride because the money brought by the bride was not sufficient for their greed. And once the family is greedy, once Mahatma Gandhi said that there is enough for everybody's need, but not for greed. The same was becoming true for the women who were marrying also. Even after bringing the money, it was not the need, but the greed of the family, which never stopped. A lot of bride burning was happening, and therefore we got this legislation, 498A, amendments in this legislation as well. In the Dowry Prohibition Act, and we can look at that in more detail day after tomorrow, the definition was anything, any property taken, given, demanded at the time of marriage, before marriage, or at any time after the marriage, as a consideration for marriage. So the question was, what is the money which is given, demanded, etc., as a consideration for marriage? So this was taken in the context of the Contract Act. So constitution means that this should be the criteria, but for this, the marriage will not take place. So that was the definition at that point of time, which got amended later on, and it became in connection with marriage. So then that's where my article has now finally come in, and I was very disturbed with this that the amendment was made that it has to be in connection with marriage. But the meaning of the word remains still that if the marriage will not take place, but for this money to be given either before marriage, at the time of marriage, or any time after the marriage. अच्छा आपके पास आज नहीं है तो आप एक साल बाद दे देना, पर पैसा तो आपने देना है. इसी प्रॉमिस पे शादी कर रहे हैं कि आप एक साल के बाद में 5 लाख रुपया दोगे, या शादी से पहले इतने दे दोगे, या एट द टाइम दरवाजे पे इतना पैसा दोगे. So we have settled all this amount to be paid either before marriage, at the time of marriage, or at any time after the marriage. But it is a contract between the two parties. It was that part of it which was made punishable as dowry. So if people were giving on their own, that was not a problem. It was people were borrowing, no complaint mechanism was there. So if somebody has agreed to marry, you should still find it sometime, even now, national newspaper report appears, such and such girl sent the groom's family back home because she said, I will not give dowry. It's a national news even today. So it's not a norm that women will refuse marriages if there is a demand for dowry. Women also accept it, men also accept it, the families also do it, they still take loans. And I think I did share this with you. When my father was critically ill with cancer, I needed money to get his treatment in the hospital. It was a reimbursement scheme, so I had to first spend and then I can claim the money from the hospital. So I took loan from my CPF account, and I discovered that for my critically ill, terminally ill father, I could withdraw only 70% of my savings, my own money. It's not even the government money, and I was to pay it back, but I could withdraw only up to 70%. But if I said the reason why I need this money is my daughter's or a dependent niece's wedding, I can take up to 90%. What were we recognizing? लड़के की शादी में खर्चा तो होगा. So your father can die with 70% money, but your daughter or the niece must get married with a lot more fanfare. 90% I could withdraw. And I needed those 90%. So I said my niece's wedding with the bride, there was no wedding. They're not asking for proof, but this is the reason you have to give. So by laying down that norm, what did I say? What did the government say to me at that point of time? The Delhi University and UGC was like that. What are we were recognizing? And this is, I'm talking 1990. 1961, we said dowry prohibition. But we are facilitating dowry by saying you can withdraw up to 90% of your savings on a daughter's wedding. But if your father is critically ill, terminally ill, you need the money. We will not allow you to spend all your money. 95. So there are so many ways in which we keep on reinforcing the practice. One law says giving, taking, demanding dowry illegal. The other one says, oh, you can take loan. So certainly we are not in cohesion as to what are the norms we want to promote. So certainly we had this. So where are we? So dowry harassment. So we had these amendments in 84, 86. And now we have this whole structure in place where we say there will be a dowry prohibition officer. It also provided that what the women can do, the women's side will do that even if you're exchanging things, then make a list. So that, and that list making is seen as saying, oh, because it was found that some marriages did not work despite all the money being given, etc. So then woman is saying, return my items. So there's no evidence as to what items were given. So everybody's fighting that, no, we spent this much money on this one, we gave so many things to them, all that. So I need all the dowry which I have given back. So they said, okay, make a list. The moment you suggest that we'll make a list, the groom family think, oh, they are already prepared for divorce and separation. It's not seen in the spirit in which it was proposed, but that's what the law provided for. Let's prepare a list, and there would be a dowry prohibition officer whose duty will be to ensure that there's no harassment, etc. Some structures, some more serious punishments are provided for. So some changes were made, including this change which I was suggesting to you, that the definition of dowry changed. But did the implementation of the law change? Whether about bringing about changes in the law, did it bring about any change in the implementation of that law? And we can look at this. Okay, then more amendments I'm also mentioning. Criminal Law, Second Amendment 883, 498A. I didn't insert it, that this offense of 498A will be non-bailable, cognizable on the complaint of the woman, her relatives, or authorized public servant. So it was non-bailable but not cognizable, cognizable only if the woman complains. So the whole burden is on her. So if she makes a complaint of 498A, the manner in which we have said earlier, if she filed a complaint against the husband, she has to file. Nobody else can, or on her behalf, somebody else will file. Criminal law will set in motion, which means arrest will take place, will go to prison. So the first thing the in-laws will do is to throw her away. So she got a criminal remedy in the 498 legislation, 498A in the IPC. So at that point of time, in 1983, all these changes were made. 174 and 176 were also introduced, compulsory inquest and postmortem if the married woman died in suicide or suspicious circumstances within 7 years. Under 13A Evidence Act, may presume abetment of suicide by husband or relative when woman committed suicide or died in suspicious circumstances within 7 years of marriage, and she was subjected to cruelty. So 498A, did we look at that earlier? I think we did. When we said what is the cruelty which has been accepted, recognized, 498A does not have a limitation of 7 years. But the other changes had a limitation of 7 years. Assumptions were created only if she dies in the 7 years. So somehow 7 years is seen as the magical year. If you cross that, then you are safe. So it is still that point of time, you need more support of the law, but after that you are safe. But cruelty can still continue. You will not die, you will not commit suicide, you will not be killed after 7 years. So we will come to your rescue, will not your rescue actually. If you have died, you are not there anymore. So then we will make the life of the husband and husband's family more difficult if you die. But if you're alive, then we'll continue to have this provision 498A, which said conduct as is likely to drive the conduct of a, what is that word? 498A? One thing to be noticed about 498A is that it is a new chapter. Before that, we have offenses against marriage. Chapter 20 is offenses relating to marriage, in which we had adultery, we had bigamy. So we had those kinds of offenses which are seen as offenses against marriage. Cruelty by husband was not seen as an offense against marriage. It was chapter 20A, new chapter added. So it was not one more section added to chapter 20. A separate chapter had to be created of cruelty by husband or relatives of husband. So when the husband is cruel to the wife, it is a husband-wife scenario. It's got nothing to do with the marriage institution of marriage. It says whoever being the husband or the relative of the husband of a woman subject such woman to cruelty shall be punished with imprisonment, which may extend to 3 years and shall also be liable to fine. Maximum 3 years. Now, what is the conduct which will be attracting 3 years? Cruelty means any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb, or health, whether mental or physical, of the woman. Or harassment of a woman, where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of failure by her or any person related to her to meet such demand. The second part is talking about dowry, money is being asked. The first one, the harassment, the cruel conduct can be for any purpose. You are not tall, you do not speak English, um, you do not know how to cook, you have put too much salt, any of that can be part A. And if it is demand for money, then it is part B, that is cruelty. In the part A, it should be such conduct as is likely to drive the woman to commit suicide. So that conduct, at the most, is punishable if proved to be having with the truth maximum 3 years. So once you look at the penalty part of it. So here is a woman's life is at stake. You're driving her crazy, but maximum 3 years. The other one, cause grave injury or danger to life. So what is grave injury? What will be the meaning of the word grave injury? We're talking about grave physical injury, for example. What will be an example of grave physical injury?
Potential to be fatal.
Hmm? What did you say?
Potential to be fatal.
Oh,
Potential
that's
to
the
be
next part.
fatal.
No, that's the next part. Danger to life. से पहले है grave injury.
Um,
Injury is
incapacitated.
physical only, is it?
नहीं, mental physical दोनों बोले तो let's talk about first let's talk about the physical injury. What will be grave physical injury?
In injury caused to uh, any body part.
Now look at section 320, grievous hurt. So we have all these categories there, 7, fracture, dislocation, blah, blah, blah. So grave injury would at least be grievous hurt. It's not just any injury. So the husband gives a thappad occasionally to the wife, which is what we have been talking about. Whether that's part of 498 definition, a thappad here and there. Is it a conduct which is likely to drive the woman to commit suicide? No. Is it grave injury? Can it cause grave injury to her? No. Can it cause danger to her life? No. Life, limb, or health. Danger to life, limb, or health. So what is danger to life? When you are seeing in the context of when it says life, limb, or health, is it talking about a thappad? That's also danger. One who give a thappad, that's also no limb to hai nahi usme. On the face, it doesn't work. To limb or health, whether mental or physical of the woman. So the definition itself has been created in a manner that the kind of violence women face on a day-to-day basis is not part of this definition. She has to be subjected to very, very serious violent conduct, which will attract 498A. And then the punishment for this is maximum 3 years, compared to the punishment for causing grievous hurt. Punishment for causing hurt by dangerous weapon it can extend to 3 years. For hurt, voluntary causing grievous hurt, it may extend to 10 years. So if anybody else causes the same injury to you, then that person is liable up to 10 years. But if it is the husband or his relatives, then maximum 3 years. What are we still saying? And this is a law made specifically to deal with cruelty against married women. Husband or relative of husband or woman subjecting her to cruelty because it's a husband. So even when he causes this grave category of violence against her, maximum 3 years. Again, same thing. Whenever we said rape by the husband, maximum 2 years. Now we have set some minimum mandatory now. But we continuously keep on treating the violent husband as a different category of offenders than ordinary persons causing the same injury to other persons. So when we are recognizing there's a violence in the family, should it be even more severely punished than hitting a stranger? Because with a stranger, you had no love and affection, you had no responsibility. You got angry, you beat him up. So that's 7 years, 10 years, actually, grievous hurt. But if you are hitting a person towards whom you have a responsibility of care and you violate that, is it sufficient punishment prescribed? That was the message to be given. The third thing, we keep on finding that same things keeps on getting repeated itself, and people asking for law are happy that we got 498A, and despite the limitation of the language in this scenario, we have this whole discourse on abuse of this law by women, false accusations. And then the second one has been that all the violence is caused by mother-in-law to the daughter-in-law without asking the question, why is even if she's doing so, why is she doing it? In how many cases she is torturing the daughter-in-law for property for herself? She's torturing her for property, things, etc. for the husband, for the son. Son will have a car. Is she going to drive the car for her to ask a better car? Is she going to be sitting in the office if she's asked for the office space? She's asked for 5 lakh to open the office for the son. Is she going to run that office? So she is now playing for the interest of the son. But she is also part of that whole patriarchal thinking. And the son is very conveniently ignoring all this. He doesn't lift a finger to either stop the violence because ultimately he will be the beneficiary. The father-in-law also doesn't lift a finger. Son's progress also doesn't matter. So these two men who remain outside the home, they play ignorance, non-participation in the violence being inflicted by the mother-in-law. But are they so innocent as they are presented to be? The violence is happening in the house. So certainly we have got all these questions to answer. So one was this law which was changed. The second one was in 1986 when we got the 304B. These are all your sections there. In this whole question of second part also, made an unlawful demand for property or valuable security. Now, what is an unlawful demand? It is traditional that the girl side gives gifts to the family of the daughter newlywed on her first Diwali. तो ठीक है, पहले दिवाली पे 20,000 रुपए दे जाओ. Is this an unlawful demand or not an unlawful demand? Traditional है, आप tradition में देते ही है. Is it an unlawful demand or not an unlawful demand? और बहुत dilapidated हालत में है, लड़की आपकी सुखी रहेगी, थोड़ी रिपेयर कराने के लिए 50,000 रुपया दे दीजिए. Is it an unlawful demand? How do you interpret the word unlawful demand in this section? How have the judges interpreted these phrases? Are these demands within the meaning of dowry, or they are not within the meaning of dowry? This question we will consider in our next to next class. Today we want to look at uh, 304B in 1984. Again, look at the language. Woman is to be dead for this section to be attracted. And again, 7 years. Lots of words are there other than normal circumstance. It will be burns, bodily injury, or otherwise than normal circumstance. Then it has to happen within 7 years. Plus, it should be shown that soon before her death, she was subjected to cruelty or harassment by her husband or relative of her husband, or in connection with any demand for dowry. Such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death. Dowry shall have the same meaning as is given in Dowry Prohibition Act. And then said, in this one we provided not less than 7 years, but may extend to imprisonment for life. For this punishment to come, she must be no more in existence. She must not be alive anymore. And for me, this has been a very, very troublesome case for many years. And it is on this case basically that I started writing the paper that I've asked you to read about. So in this case, the husband and the in-laws were causing a lot of taunts to her. So one night, the husband too played and was saying too much salt in the food. And of course, more taunts followed. And then somebody made a remark saying, "Jaake mar kyun nahi jati? Railway line idhar hi hai." So she very promptly, 4 a.m. in the morning, goes to the railway line to kill herself. And unfortunately, she didn't die. She became paraplegic. I would urge you to read this case. We can have some conversation about it tomorrow. No, not tomorrow, day after tomorrow, because that will read the original case, then read my article, and we can talk about it in our next class. But tomorrow we want to look at the dowry, the DB Act, Protection of Women Against Domestic Violence. So 498A, the major problem with this whole thing was all criminalization, and criminalization did not help the women at all. And therefore the DV Act was brought in to deal with the scenario that when she has her main concern is to have a shelter over her head and over the head of her children. So therefore, the new legislation comes. So tomorrow we will look at that legislation. I want you to think about this question, Satveer Singh, whether this case has dealt with the problem which the victim was having and must have been having since the incident when she became paraplegic. The session judge has convicted the person for 306. This is a very classic case of how technically the judges interpreted the sections and how they absolved him from various liabilities of attempt to 304B, of 498A. So there were all these classical arguments are there. So pura baal ki khal karke, and they kind of finally convicted him only under 498A, and imprisonment already undergone. Enhance the fine from rupees 5,000 to rupees 1 lakh, and this is to be paid to the victim. So I want you to think about this case. Read this case first and then see. So then we will come back tomorrow, and so more amendments I've mentioned to you earlier. Then we will look at this legislation, some of the important definitions, and the question you should be focusing for tomorrow is, what is domestic violence? Who may be the aggrieved violence? What are the remedies available to the victim of domestic violence? and who may be the respondents. So we'll stop with this today. And unless you have a question or any observation from what we talked about today, we'll stop. I'm finding I'm talking too much, and your participation has become very less. Soumya is busy taking down notes. She's not participating anymore. And Ankit has also gone quiet. The other two had very occasionally spoken. I can't see them, so I do not know whether they're taking notes, whether they're only listening and thinking. I never had such monologue classes in gender justice as I'm having this semester. Very distressing for me. Soumya is all in examination mode now.
Yes, ma'am. Tired a little bit today.
Yeah, I can see it. That you are all thinking, oh, examination में क्या क्या लिख सकते हैं.
Ma'am, Satvir Singh versus State of Punjab 2001. Is it in this case?
Yeah, look at it, is dowry case ना. ये सारे sections लिखे हैं उसमें. पंजाब का ही है. सुप्रीम कोर्ट का है जजमेंट. इसे प्रॉपर साइटेशन अगर ढूंढ रहे तो वो मेरे आर्टिकल में भी मिल जाएगी. मैं देखते ही बता देती हूँ.
And these topics are generally very distressing also to discuss even.
Satvir Singh is 2001 8 SCC. This is a 2001 case. Okay. It took me a long time to write that article, but since that we were teaching this case at one point of time in our criminal law, I always used to feel like, what what you do with this kind of interpretation. That how the judges have tried to find ways and means to say, no, this does not apply, this does not apply. And imagine what the woman has suffered and how we are dealing with the technical interpretations of the sections and provide barely anything for her. So it's a very technically sound judgment, perhaps, but whether that's the purpose, does that meet the purpose of the law? So again, this whole question about when you're dealing with the socially sensitive situations and social practices, legislation dealing with social evils, what should be our approach in interpreting those sections? Should we be finding ways to support the women, or should we be finding ways and means to say strict interpretation, all benefit goes to the accused person? Whether our approach, should it be contextual? So all these are the questions which Satvir Singh leaves behind for me. And whether there was a possibility of writing a different judgment. All those. So please read. So tomorrow, what time are we meeting?
Same time.